Greetings and welcome to Law of Evidence Relating to Official Conduct from American Jurisprudence. I'd like to invite everyone that has arrived to please hit the like, make sure we get the notifications out there, have as many people in here to contribute along with the lesson here as we do a reading from American Jurisprudence, second edition. Let's get right down to it. So, we're on to, I guess this would be or part 1, letter A of Official Acts, Duties, and Proceedings, and section 202 is where we will start, generally. And before we get started, just to remind everyone that this is strictly for the educational entertainment purposes of this YouTube broadcast, only, not to be used, misconstrued, or mispurposed for anything personal, professional, legal, lawful, tax, or financial, or otherwise. So please don't do this at home. All right, let's begin. Public officials and agencies are presumed to act in good faith and in accordance with applicable law and regulations. Oh boy, we're off to a good start here. That's People versus Good Enough. Good enough? All right. Writ of error over. All right, let's continue. Where an official act is shown on its face to have been regularly taken, it is presumed to be regular and valid in all respects. Such a situation arises when a party seeks to prove that an agency or officer who is not party to the case acted in a certain way to support some other inference. So the situation here, to have been regularly taken, presumed to be regular and valid in all respects, arises when a party seeks to prove that an agency or officer who is not a party to the case acted in a certain way to support some other inference. That's footnote 41. I think I see where we're getting at here. Okay, just the citation. Let's proceed. For example, some judgments imposing prior prison sentences constituted court orders directing the prison warden to carry out the judgment and permitted the presumption that a public official acts in accordance with his or her duty and satisfies the prosecutor's burden of proof that the defendant actually served the sentence, unless defendant offered sufficient evidence rebutting the presumption. Wow. The law's recognition of the probability of official regularity is applied in other contexts as well, such as at an evidentiary hearing, in which a party challenges the validity of a public agency's act or decision, where the challenger has the burdens of production and persuasion to prove invalidity. Nice. So let's get this one again. This is very relevant here. The law's recognition of the probability of official regularity. Remember, this is a presumption. Presumptions are not evidentiary conclusions. They are probability of a presumed fact beyond a reasonable doubt or some other standard. The law's recognition of the probability of official regularity is applied in other contexts as well, such as at an evidentiary hearing. So that's where they'll have the recognition of the probability of official regularity, in which a party challenges the validity of a public agency's act or decision, where a challenger has the burdens of production and persuasion to prove invalidity. So that would be at the evidentiary hearing, it seems. This is just the same comma here. Courts often refer to a presumption of official regularity and propriety, but it is more precise and accurate to eschew the term presumption in this context, huh? And refer directly to the petitioner's burden of proving impropriety. Nice one there. Let's see here. Footnote 44. Person versus Department of Social Services. This is a party appealing the denial of public assistance has the burden of proving its entitlement to the benefits. Now, that's interesting there. All right. So, impropriety. Okay, that I guess in this context here for 44, proving its entitlement to the benefits, saying that they were trying to, I guess without having that, there was no impropriety if they weren't entitled to anything, if they didn't act. Okay, when assessing the fairness of an agency's proceeding and the validity of its action, a court's scope of review is generally limited. In expressing this principle, courts sometimes refer to a presumption that the agency's action was valid and speak of a party's heavy burden of proof to overcome the presumption. Heavy burden of proof. When used in an evidentiary hearing, such statements describe the burden of persuasion imposed upon the party seeking to overturn the agency action. That's footnote 48. Let's see here. Basin area rates. Okay, just the citation there. All right, so we've gone through our footnotes here. Footnote 43, we did a non-final order entered by the Department of Agriculture in favor of growers in a dispute with a fruit picker producer. Created a presumption that growers were entitled to relief. That is, imposed upon the picker producer the burden of producing credible evidence to the contrary at the department's final hearing. Wow. Nice. So I guess the past act. And footnote 46 here, citing the presumption of validity and reasonableness in upholding the decision by the State Council on affordable housing to rely upon a 10-year-old state development guidance plan in assessing whether the township had complied with the state's Fair Housing Act, explaining that review is limited to whether the official or agency exceeded its authority or acted illegally, arbitrarily, or fraudulently. Court cited the presumption that a public agency acted properly. West Virginia Human Services. Interesting there. All right. We're on to the next section here. 203, presumptions related to government officers. Okay, let me check over here to the chat. There we go. All right. Okay, yeah, geez, had to refresh this one here. Audit them. Greetings. Let's make sure we get this fully refreshed. And El Perro, good to see you here. Like the new logo. And power inherent in the people, outdoing the people's work. Tomorrow night. What's happening tomorrow night? Well, we'll get to that at the end here. Give me whatever information we need. We'll get that out there. Yes, and good to see Word Wizard. Yeah, at the end of this presentation, I have a special surprise for New Year's in 2025, and I think it's going to be music to most of your ears. And it won't be a song. It will be actual, some very useful and inspiring information. So stick around to the end for that for sure. Okay, so we're on to presumptions related to government officers. I want you all to keep in mind that what we're looking at here is the basis of how every single case that I've seen against bad actors within governmental positions are based on presumptions that somehow weren't rebutted properly and got admitted into evidence, and that's why the injured party wasn't able to prevail, at least into the degree they most likely should have, regarding justice. So, that said, it really behooves us to learn the essence of these presumptions of government officials and official service. Let's continue. Until the contrary appears, due appointment to office may be presumed from the fact that one has acted in an official capacity. Until the contrary appears, till it's rebutted, due appointment to office may be presumed from the fact that one has acted in an official capacity. Once they've done the acts, they're considered. The acts of that official capacity, that appointment to office may be presumed. In the absence of evidence to the contrary, the law assumes that the public officials have performed their duties properly, unless the official act in question appears irregular on its face. Okay, so prima facie irregularity, now that presumption is not standing so well. Let's continue. A public officer acting in his official capacity is presumed to act with knowledge of what he is doing and of the material facts upon which his official action is predicated. In his official capacity is presumed to act with knowledge of what he is doing and of the material facts upon which his official action, what he is doing, is predicated. That's footnotes 52 and 53. Pan American Petroleum, wow. Appeal after remand. And we have 53, United States Chemical Foundation, wow. Superseded by statute on another point. It's stated in Blue Cross also. Blue Cross and Blue Shield Association. So this United States Chemical Foundation must be a landmark suit, but I digress. Let's continue here. The presumption has been applied to the acts of almost every class of federal officers, including the President of the United States. Wow. And that's back to 54, United States versus Chemical. So I guess it is. If the President removes someone from office, it must be assumed that he acted with reference to his constitutional duty to faithfully execute the duties of his official position. Heavy stuff here. All right. Wow, that's a good one. Cabinet officers and their assistants, and all other federal officers, such as agents of the Treasury Department. Similarly, the presumption applies. Oh, this is a good one. Similarly, the presumption applies to state officials, including the governor of a state, the secretary of state, the attorney general, and his assistants, the state highway commissioner, the insurance commissioner, a superintendent of banks, that's footnote 62, and lesser state officials such as a water commissioner, a tax assessor, and a receiver of an insolvent bank. Let's look at these footnotes here, starting with 56. An assistant Secretary of the Treasury must be presumed to have had the power to order that a position of customs inspector be abolished, where his action was reduced to writing and became a part of the archives of the department, does not appear to have been modified or in any other way changed by the Secretary, and there is nothing in the record to show that his action did not have the full sanction and approval of the Secretary. Wow. See, the rest are just the citations. Take note. Lots of them there. Lots of research if you want to see more details about those. Lots of them here. Look at this all. Oh my gosh. All right, now we're on to section 204, Administrative and Regulatory Agencies and Other Public Bodies. Before we do that, let's jump back over here to the chat and see where we're at. All right, El Perro says, sorry, can't post link, but it is titled U.S. Department of Defense Standards of Conduct Office, Encyclopedia of Ethical Failure. I'm sure that's a little too thick to cover. Oh, and that's only from 65. Can only imagine where they're at now, huh? Some 60 years later. Goodness. Coupled with the fact that a county sheriff's department generally has specific procedures directing the performance of acts with respect to the execution of warrants, would strengthen the plaintiff's assertion that a ministerial duty had been violated. Indeed. That's a Georgia Tort Claims Act. Cool. At them. Yes, stay tuned. It only gets better as we go along. Good to see you all here. Let's continue. Courts have shown deference, whether by recognition of a presumption, allocation of burden of proof, or application of a maxim defining the scope of judicial review to a variety of agencies, both federal and local. For example, the grant of a patent for an invention carries with it a presumption of validity and operability. A presumption of validity attaches to acts, regulations, and decisions of the Board of Immigration Appeal, the National Labor Relations Board, and the Securities and Exchange Commission. Operability and validity, nice. Those are some good terms here to know if you have a patent. Similarly, courts show deference to a wide variety of state and local agencies, including a Department of Agriculture and Consumer Services, a city council, a state corporation commission, a board of education, a board of highway directors, a housing council, a board of prisoner directors, and a public service commission. And here we go. With all these great, these are what we call the administrative and regulatory agencies and other public bodies where courts have shown deference by recognition of their presumption, carrying out their official duties, that their duties are official, they're performing those duties, they're rightfully appointed, etc. All those great presumptions that we read about earlier. So, just to be known that you're not going to get anywhere in a case until you shot down these presumptions, because these are more than presumptions. These are under that good faith that these particular public bodies and such, right? Deference, allocation of burden of proof, or application of maxim defining the scope of judicial review. Interesting stuff here, and that's Radio Corp of America versus Radio Engineering Laboratories. So we got some pretty old case holdings here. And that's it. Here we have another note here. In an action to restrain a school board from excluding a minor from school because he had not complied with school regulations with respect to his haircut, it was presumed that the rules adopted were based on mature deliberation and for the welfare of the community, as a rule in this case had a reasonable connection with the successful operation of the school. Geez, Massachusetts. All right. I digress. We're on to Section 205, Legislative Acts. El Perro says the way they could still be documented with these statistical historical values, program of economic warfare, known as trading with the enemy act. Yeah, this is well, that's a whole nother read in itself, indeed. All right. It is often said that the law presumes the regularity and validity of legislative acts of all levels of government, including the official acts of Congress, state legislative bodies, the electorate at large, acting by initiative, municipal ordinances, rules and regulations adopted by a city commission or board, and disciplinary rules and regulations promulgated by a board of school trustees. So it is often said that the law presumes the regularity and validity of these acts of all levels of government. Presumes the regularity and validity. Often. Hopefully more often than not. So we can see that's been stated, and I guess if you say something enough, people will start to believe it. Oh, here's a good one here. Milwaukee Company or Milwaukee Cooperative of Jehovah's Witnesses versus Mullen. They did have quite an illustrious esquire arguing for their organization. Great attorney at large. All right, section 206, quasi public officers. All right, the presumption of regularity has been applied to acts of quasi public officers such as administrators and executors, a guardian ad litem, and a notary public. Quasi-public officials. Administrators are quasi-public officials, and executors, quasi-public officers. Same with guardians ad litem and a notary public. So, back over to the chat. That one there, let's audit them, the quasi-public officers. As we've seen him deal with quite frequently in his videos, make sure you subscribe to audit them. All right, we're on to Part B, regularity of judicial proceedings. Oh boy, this is the meat here. Section 207 to 213, generally. When any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that the court complied with the formal requisites for its validity. Whenever an official act is shown to have been done in a manner substantially regular, keyword, substantially regular, then it can be presumed that the court complied with the formal requisites for its validity. The burden is on the individual challenging the action to show unlawfulness or illegality. Footnote 4, United States versus Roses. The law presumes, absence of strong showing to the contrary, that a grand jury acts within the legitimate scope of its authority. I would certainly hope so. All right, we're on to section 208, subject matter jurisdiction. Yeah, El Perro, we did a great one on the Chevron doctrine where we looked through, I believe this is too, an older edition of American Jurisprudence, and had we did a follow-up with the cases that it had hanging within that version there, and got up to the more updated ones about the Chevron deference ruling and the implications it had. So if you look for there, I think, I can't recall the name there, but it's definitely in the, I think it's the administrative law. It's not on the AmJur playlist. It would be on miscellaneous. And it says only people would and could read with comprehension. And that's the goal here, El Perro, is for us to comprehend the complicated readings here and make them more simple. One thing I do like about the style of American Jurisprudence is it does break down. It starts with the complete concept and then slowly breaks it down, more and more details, and finally you get to your footnotes, which is the finest of granularity there. So it is a good way to approach this, even for a novice, and that's why I try to make it so that we could still learn this at the highest level of law logic, yet still have it in a manner that an elementary school child would be able to keep along with what we're talking about, at least in a conceptual issue. All right, so we're on to the subject matter jurisdiction. The law presumes that a court has acted within its jurisdiction in the absence of a clear showing to the contrary. Good luck getting an esquire to point that out for you. Where the judgment recites the facts conferring jurisdiction, the recitals are presumed to be correct. Presumed. Remember, the presumptions are unrebutted inferences. So they're starting with a basic fact, but then they're working a logical inference that leads from that basic fact to the presumed fact. That becomes their presumption, which guides the case here. This presumption is rebuttable in a subsequent direct proceeding between the parties to the judgment. Wow. In a collateral attack on a judgment, the law presumes the original court acted within its jurisdiction. That is, defendant has the burden of proving lack of jurisdiction, even if the jurisdictional facts do not appear on the record. So, as we can see, subject matter jurisdiction rarely, if it even has to appear on the record. So the burden of proving lack of jurisdiction is not going to be able to point to facts on the record in most cases, it seems. And again, the law presumes the original court acted within its jurisdiction. So these presumptions, although rebuttable, seem to have some difficulties in that. We can see here in the footnotes. An appellate court cannot presume the absence of subject matter jurisdiction in a case in which the record does not disclose a lack of jurisdiction. Bingo. Record does not disclose a lack of jurisdiction. And as we read here before, there's many ways we could get onto the record things of this nature, if they are facts indeed. Instead, any presumption is in favor of the trial court's action, deciding the jurisdictional question presented. So, once again, we see here, any presumption is in favor of the trial court's action, deciding the jurisdictional question presented. So it's always going to be something that should be challenged, although it can be challenged at any time. That subject matter jurisdiction is best dealt with in the earliest part of the process as possible. Now we're on to section 209, courts of general or special jurisdiction. And okay, geez, I have to refresh the chat here. Here we go. Damn, all right, nice. All right, so, Chevron isn't quite as a tendency in Romans 13. Yeah, and I mean, although the law has to deal with the more complex issues of controversy, they are rooted, especially in common law, in our American jurisprudence, in the basic elements of justice, natural law to some extent, but the whole thing of the maxims of law guiding the judgment, not arbitrary or capricious decisions of rulers. All right, let's proceed here. A court of general jurisdiction is presumed to have jurisdiction unless someone proves that there is some valid constitutional or legislative enactment that has withdrawn jurisdiction in a particular case. Footnote 10. With regard to certain inferior courts, let's see here. Okay. With regard to certain inferior courts of special and limited jurisdiction, however, the presumption in favor of jurisdiction does not apply. Because an inferior court's judgment enjoys no presumption that it was within the court's jurisdiction, the judgment of such a court should affirmatively demonstrate through the record or minutes that the court acted within the scope of its authority and that all essential jurisdictional facts existed. Wow, that's a huge one there. Footnote 12, application of Roswell, 1st District. First on the grounds. That's one to look into a little bit deeper there. Certain inferior courts of special and limited jurisdiction, however. Okay. It does not necessarily follow, however, that the judgment is absolutely void if the matters essential to jurisdiction do not thus appear. Although there is no presumption in favor of jurisdiction, it has sometimes been held permissible to show the necessary facts by extraneous evidence. It is also sometimes held contrarily that where a court of limited jurisdiction does not show affirmatively, on the face of the record, that the court has authority to act, the order of judgment of court is without jurisdiction and void. Void meaning it is on its face invalid and as if the proceedings had never occurred. So let's see here. It does not necessarily follow that the judgment is absolutely void if the matters essential to jurisdiction do not thus appear. As we saw, it doesn't have to appear on the record. Although there is no presumption in favor of jurisdiction, it has sometimes been held, sometimes, permissible to show the necessary facts by extraneous evidence. Wow. It's also sometimes held contrarily that where a court of limited jurisdiction does not show affirmatively, right? Affirmatively, they have to show it positively that they have some kind of limited jurisdiction on the face of the record, that the court has authority to act, the order of judgment of court is without jurisdiction and void. That's a very powerful point there. And there it is for your notes. The rule that no presumptions are indulged in favor of the proceedings of inferior courts applies only to the question of jurisdiction. Wow. These courts, like others, are presumed to have acted correctly as to matters within their jurisdictions. The caveat right here, that's gold. And let's see here. A small claims court judgment has res judicata effect. A civil action filed in appellate court cannot be dismissed on grounds that it was based on matters tried and determined in a lower magistrate court. That is, the magistrate court was not competent to rule on the matter. So this is a great point here. I want to read this one again here about the rule that no presumptions. Second here. Oops, okay, here we go. So refreshing the chat here. As Alpero says here, this is why jurisdictions should be questioned at all times, so it's never presumed. It should always be questioned to the extent that there is a question. If it's, on its face established, then yeah. But whenever there is a controversy involving jurisdiction, it should be challenged. And judgments are void. See, Alpero saying summary judgments are void. The fact they remain merely summaries based on those presumptions. I think what we read earlier about judgments, summary judgments would be voidable, but not necessarily void. So you could have further proceedings that could void the summary judgments, but on their face, they're not void in some cases. As you said here, as relates to probate, which will be, stay tuned, the next episode we get into probate on this law of evidence. But okay, let's get back to the presentation here. I want to read this one more time. The rule that no presumptions are indulged in favor of the proceedings of inferior courts applies only to the question of jurisdiction. So no presumptions only applies to the question of jurisdiction. All the other presumptions in those inferior courts are presumed to have acted correctly as matters within those jurisdictions, but that jurisdiction's not presumed. Everything else is. And as we're reading down here, here we go. Yeah, so again, the important thing here is a small claims court judgment has res judicata effect. This shows the superiority of a small claims court. This is just incredible here. This little piece here is a gem. I don't think most people can comprehend this fact. Anyways, we also have here a civil action filed in appellate court could not be dismissed on grounds that it was based on matters tried and determined in a lower magistrate court. That is, a magistrate court was not competent to rule on the matter. Wow. So this would be interesting to read too. In the annotation here, res judicata as affected by limitation of jurisdiction of court which rendered judgment. So, as we saw here though, this is just out of a small claims court judgment has res judicata effect. I've got to look into this case here, Doherty versus McMillan. I don't think most people would realize how huge this is. But let's continue. Here we go, probate courts, section 210. And before we get into this, let's jump over here to the chat. Yes, clarify by authority. Exactly, El Perro. All right, so we're on to the probate courts. The authority given to probate courts is governed by state statute. Hence, the records of their judgments in some states must show on their face the jurisdictional facts conferring power on the courts to enter judgment, and no intendment will be made in its favor. Footnote 16. Let's see. Probate courts are not courts of general jurisdiction and are not subject to the rule of presumptions as to jurisdiction. They don't get presumption of jurisdiction in a probate court, huh? Most courts, however, view probate courts as courts of general or superior jurisdiction in respect of the settlement, distribution, and partition of estates coming within their cognizance. Orders and judgments of such courts are entitled to the same favorable presumptions and the same immunity from collateral attack as are those of courts of general jurisdiction. All right, now we're on to, let's see what we have here. A probate court acting within its statutory powers is a court of general jurisdiction whose judgments are immune from collateral attack. All right, now we're on to section 211, judgments in other states. Jump over here to the chat, make sure we're all refreshed. All right. Under the doctrine of comity, and under the doctrine of full faith and credit, as we went over in a previous episode, the judgment rendered by a court in one state, referred to hereinafter as the judgment state, is generally enforceable by the tribunals of a sister state, hence, hereinafter, the forum state, unless the judgment was invalid. Unless the record demonstrates lack of jurisdiction on its face, the forum state court will assume that the judgment was properly rendered, that is, the burden of proof upon the defendant to establish that the judgment court lacked jurisdiction, and this is true even though the facts upon which the jurisdiction depend do not affirmatively appear. If defendant claims the judgment court lacked jurisdiction to render the judgment according to the laws of the judgment state, defendant has a burden of proving what the law of the judgment state is. Wow. If the party supplies a forum state court with the necessary materials and information, in most states, the forum state court must take judicial notice. As I was going to get to that, we read about this in the judicial notice episode of the laws of the judgment state. If the party fails to provide these materials and information, the forum state court may take such judicial notice sua sponte. So, court would be acting on its own behalf in this matter here. Interesting. But is not obliged to do so. Instead, the forum state court may presume that the law of the judgment state is the same as that of the forum state. Wow. This latter presumption should be applied, however, only if it is consistent with the presumption that the judgment state court acted within its jurisdiction. Consistent with the presumption. Nice. I think we're starting to work here towards our pyramiding of inferences or pyramiding presumptions. Unless extrinsic evidence or record establishes that the foreign court lacked jurisdiction to render a judgment, a state court will presume that the foreign court did have jurisdiction. Wow. A foreign judgment, regular on its face, is entitled to a strong presumption that foreign court had jurisdiction over both parties and subject matter, and that court followed its laws and entered valid judgment. The burden of overcoming this presumption of validity is upon party attacking the judgment in subsequent proceeding. Wow. Sounds like a whole new trial. But at least you could challenge a foreign judgment. Judicial notice of foreign laws. We went over this one already. A court may make its own independent inquiry into jurisdiction of a court which rendered judgment by examining laws of judgment state. Wow, independent inquiry into jurisdiction of the court. All right. Now we're on to section 212, service. Beautiful part here. Let's jump over here to the chat. Hope everyone is still here. Just refresh us here. A moment, and there we go. I think we're all there. If you haven't already, please hit the like. Make sure we let everyone know we're here in case notifications are still thin. And let's proceed. When the civil rules regarding service of process are followed, there is a presumption that service was valid. When the civil rules regarding it are followed, there's a presumption that the service was valid. This presumption, remember, an unrebutted inference, is based on the premise that judicial acts are duly and regularly performed. No such presumption is indulged for service prescribed by a statute or rule for substituted or constructive service. Strict compliance with statutes which allow service on non-residents will be enforced, and no presumption of regularity will be followed. The inquiry in those situations must be as to whether the requisites of the statute have been complied with, and such compliance must appear on the record. Wow. So no presumption is indulged for service prescribed by a statute for substituted or constructive service. No presumption may be given effect, however, against the express statement of the record. Wow. That's a good one there. See footnote 30. Citation there. In addition, there is no presumption of validity when direct attack is made upon default judgment. When there's a default judgment, there's no presumption of validity. Interesting. All right, let's read these footnotes if there's anything else in here besides the citations. Footnote 29, electro-engineering products versus Lewis in Florida. To withstand an attack on service under a long-arm statute, a plaintiff must substantiate jurisdictional allegations in the complaint by affidavits or other competent proof, not merely reiterating the factual allegations. Wow. Wow. Plaintiff must substantiate the jurisdictional allegations, not merely reiterating the factual allegations. Oh, what a great technicality there. And we're on to section 213, regularity of proceedings subsequent to gaining jurisdiction. Oh boy. And jumping over to the chat. Let's see here. Oh, okay, good. It's refreshed here. Diesel for We the People News says, always rebut presumption. I'm led to believe Happy New Year's, people. Indeed. Always rebut presumptions if they're not in your favor. The presumption of regularity applies not only to the fact of jurisdiction, but also to the proceedings subsequent to the gaining of jurisdiction. Oh, wow. The proceedings subsequent to the gaining of jurisdiction. Wow, regularity. When the jurisdiction of a competent court has attached, every act is presumed to have been rightly done until the contrary appears. So there's another presumption there. The presumption of regularity. subsequent to gaining jurisdiction. Unless the record shows contrary, it will be presumed that the trial court gave due consideration to testimony appearing in the record, that a criminal defendant was properly arraigned, that the court considered sending defendants to a state youth facility, that a defendant did, as indicated by court records, serve a prison sentence for a prior conviction, thereby qualifying for enhanced sentencing, that the trial judge found preliminary requisites to the admissibility of evidence, and that the jury followed the instructions given to them. Okay, so that's a criminal case there. Trial court's finding that a co-defendant had testified under an immunity agreement and was entitled to the presumption of correctness. Wow. Review court should presume that trial court followed the law until the contrary is shown. Are we catching a common theme? In the absence of evidence to the contrary, it is presumed that a court of general jurisdiction has proceeded within the general scope of its powers, and this presumption of regularity attaches with particularity to judicial proceedings in which the jurisdiction of the tribunal is unquestioned. Powerful stuff here. Tribe. All right, that takes us to the end of this episode here with that serendipitous footnote. Next episode will be into relating to the family, and just as a quick glimpse here, we're going to see about marriages, existence and validity, starting with ceremonial marriages. We'll have common law marriages, all the good stuff in here on the family. This will be definitely a family-friendly episode coming up next. But that takes us to the end of this broadcast for tonight. Jumping back over here to the chat. Fifth Circuit's always used trickery awards. Always challenge jurisdiction in the courts. Yeah, whenever you can. If it's against your, it's not in your favor, it's always good to consider that. Of course, nothing here is considered legal advice. This is all just for the educational entertainment purposes of the YouTube broadcast, not to be used misconstrued for anything legal, lawful, personal, private, financial, tax, or otherwise, so please don't do this at home. And, here, let's see here. There we go. Now it's fully refreshed. And I believe that's it. Well, I'd like to thank you all for coming in tonight and going over the law of evidence relating to official conduct. Next time, we should be getting into the, as I said, the family-friendly episode. And, thank you for all your time to come here, and salute to you for showing you had the time to come here instead of many other things you could be doing on YouTube. A lot more interesting types of topics, perhaps, but none more relevant to us here on America than the law of evidence. How many people are still there in the chat? If you put a heads up, I'll have a special treat for the end of this, as I promised. But if everyone's gone, then there would be no point. So we're going to take a quick poll and see if there's anyone still active in the chat. And I'm going to prepare something very special here. If people don't pipe up, then we're just going to be done. But I'm going to just put on a song for a minute and a half. And by then, we'll know if we have enough willing participants to indulge in something real special. Give me a moment here. That's not going to do it, is it? Give me a second here to try to get a timer going for us. It's really going to give me a hard time like that, huh? Give me 1 second. There's one way to skin a cat. There we go. And, still didn't get it. Give me a second here. Maybe we could reset it. Oh, there we go. All right, here we go. Well, regardless, we're gonna get going. We got one person here who says yes. All right. we got something special coming up. Give it the song here while I prepare it. Forget about this timer here. It's not going to work. And let's get it going. Oh, there it is. I see it now. Okay, here we go. Okay, we're ready. So, to celebrate the new year, interestingly enough, I was able to find this incredible document here deep within the archives, or the archives, as Dem likes to call them. And it definitely is something different. I found this from a great legal scholar out there, law scholar named Dion, pointed me towards this one, and it's really something I think we'll all be pleased to read about. This is authenticated from the U.S. Government, from the GPO here. This is public law from 54 Stat, page 178 here, chapter 183. A joint resolution. This is on May 3rd, 1940. It has yet to be repealed. Authorizing the President of the United States of America to proclaim, I am an American Citizenship Day, for the recognition, observance, and commemoration of American citizenship. Notice it doesn't say U.S. citizenship. American citizenship. Whereas some 2 million young men and women in the United States each year reach the age of 21 years. And whereas it is desirable that, here we go, the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Therefore, be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that the third Sunday in May each year be, and hereby is, set aside as Citizenship Day, and that the President of the United States is hereby authorized and requested to issue annually a proclamation setting aside that day as a public occasion for the recognition of all who, by coming of age or naturalization, have attained the status of citizenship, and the day shall be designated as I Am an American Day. That the civil and educational authorities of states, counties, cities, and towns be, and they are hereby, urged to make plans for the proper observance of this day, and for the full instruction of future citizens in their responsibilities and opportunities as citizens of the United States and of the states and localities in which they reside. So notice there's a more inclusive look of citizens. It's not just citizens, American citizens, U.S. citizens, state citizens, local citizens in which they reside. Nothing herein shall be construed as changing or attempting to change the name or the time or mode of any of the many altogether commendable observances of similar nature now being held from time to time or periodically, but to the contrary, such practices are hereby praised and encouraged. Section 2, either at the time of the rendition of the decree of the naturalization or other such time as the judge may fix, the judge or someone decide. Okay, so again, this shall address the newly naturalized citizen upon the form and genius of our government and the privileges and responsibilities of citizenship, it being the intent and purpose of this section to enlist the aid of the judiciary in cooperation with civil and educational authorities and patriotic organizations in a continuous effort to dignify and emphasize the significance of citizenship. Approved May 3rd, 1940. So this was approved, joint congressional committee, joint resolution, signed into law by lawful legislatures. So again, this is American Citizenship Day, not U.S. Citizenship Day, which is a bit different of a distinction, but moreover, the best statement of all here, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. So we want to make sure the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. So this should be something where the recognition of the government of the sovereign citizens of our nation and their status, the significance of their status in our self-governing republic, has been acknowledged, and there is a lawful definition of the sovereign citizens of our nations without a pejorative attached. In fact, it's something that is praised and proclaimed by joint resolution and the president to designate a day to celebrate those who attain the status of majority as I Am an American Day. All right, so let's jump over to the chat. Please, everyone, look it up. This isn't me. This is from the archives, or archives, as some would say. Give me a second here. There we go. And here, for your reference, right here at the top, Public Laws, this is 54 Stat, Chapter 183. Diesel We the People News says people didn't start using the legal term or the particular word until the 80s or 90s. Age of majority, yes, indeed. And Lee Fuller, yes, this is great information. Well, knowing where again, to get away from presumptions, this is a fact of law. This could be judicially noticed. Next time anyone tries to call you a sovereign citizen as if you're an enemy of the state, remind them that there's a legal or a lawful definition for sovereign citizen, where it has a significance as a very important status for the self-governing republic that we all share. So I hope this has been inspirational for everyone for their new year, and I sure hope that yes, Happy New Year to you all. And I hope this leaves you all with something to think about going forward with the new year. And let's make it great for everyone here in America, on America, and for the rest of the world, as we are the only hope left to keep this great tradition of American jurisprudence and common law alive at this point in time. So let's reciprocate what was done from us by our predecessors and preserve this for our posterity. And that said, Thank you all for coming, and I will see you all on the next one. Peace out.